Islamic law, which has been dormant for almost 5 centuries, must grow if it has to solve modern problems that are faced by all humanity in general and Muslims in particular. During these 5 centuries or more, the law has grown but in a negligible or insignificant manner. One main reason for this lack of growth has been the absence of a methodology that can support the required growth. The second has been colonization, due to which Muslims have had to deal with the greed and brutality of their then colonial masters. The third and most important reason, however, has been the rise of the state as a legal person. It is, therefore, significant that the arrival of the British in India coincides with the rise of modern states in Europe. The last 2 reasons mentioned above arrested the growth of Islamic law. They took away the free environment in which the law could grow. The restrictive environment provided by the state prevented the free exchange of ideas. There was also no incentive for the exchange of such ideas as the state had monopolized all lawmaking. This situation continues even after the end of colonization, as it is now the state that has taken over all the functions of the colonial masters. In short, the natural environment in which Islamic law had grown in the first 1,000 years of its existence has been taken away. This natural environment can now be restored with the shrinking of the world into a global village and with developments in modern technology and communications. It can be done without disturbing the existing structure of states and their authority. There are 3 major points that need to be addressed. The first point is about the difficulties that Islamic law is facing within the environment provided by modern states. The second concerns the explanation of what exactly we mean by the emergence or re-emergence of Islamic law at the international level. And the third topic is about the way this re-emergence will begin. That is, what are those priority areas in which Islamic law can first contribute at the international level? We will first take up here the discussion of the hurdles in the face of the free growth of Islamic law. The state as an independent person is not owned by its citizens. It is the state that owns the citizens, just like it owns the territory under its jurisdiction, as well as everything else that exists in that territory. The state makes its citizens work and contribute a part of their earnings to the state so that it can continue to perpetuate its existence. Any resources that the state allows its citizens to own and use can be taken back when the state needs them. In order to survive, the state defends itself against internal threats as well as against external dangers. The external goal of the state is survival, while the internal goal is growth. For these 2 goals, it makes the citizens strive and work to generate the resources that are sufficient for their survival and growth. These matters do not concern us here. What does concern us here is that the state is a secular being. It can have no religion. The reason is that the state does not owe its birth to God, like man does. It cannot have the ahad, or covenant, with the Almighty that we have mentioned elsewhere. Further, as Hans Kelsen says, the state is the law. This law can only be driven by 2 goals: survival of the state and its growth. Any other law, with different goals, will be viewed as a threat by this state and its law. In addition to this, the state works hand in glove with the concept of democracy, which is also a secular concept. Its primary duty is to ensure equality. Consequently, it will try to give equal rights and opportunities even to those who will work against what the Almighty requires and who might try to demolish Islamic law and eliminate it altogether. The only religion the state will tolerate is one that is practiced within the confines of one's bedroom or living room and is taken occasionally to church. Islam, however, is not a religion. It is a deen or a system. It does not know the difference between secular and religious, or the political and religious, or Caesar and the Pope. It has a complete law with a whole system of duties that cover every aspect of human life. It has come into this world to provide solutions to world problems. especially those of the poor. It will not turn the other cheek nor consider poverty a sin, but will react with an appropriate and effective response. It is not driven by the goals of some legal person, but by the objectives of the Shariah that the Almighty has determined for this law and for those who have faith in this law. A system with these purposes is naturally seen as hostile by the creature called the state, whichever state that might be. The state may be one with a Muslim majority or one with a Muslim minority. This law, with the system it visualizes, will be seen by all states as hostile. The legal person called the state has given birth to many new kinds of legal persons that support its existence. The most formidable of these is the multinational corporation or the multinational enterprise, also called the transnational corporation. These beings have the ability to move resources worldwide, and they have grown bigger, in certain cases, than many small countries. This form of the legal person is no longer in need of territory, but it does own its employees, from whom it demands a fierce type of loyalty. It will survive even if the modern states disintegrate and dissolve into small communities. As compared to the state, it does not have to protect territory. If one territory refuses to grant it a home, another one will. Islamic law is up against this form of legal person too, as it will always view this law as hostile. All this does not mean that Islam or Islamic law is against the idea of the state as a legal person, or even that of the corporation as a legal person. The requirement of Islamic law is that humans should ultimately bear all responsibility and be held liable for whatever the state or the corporation does. The only way this is possible is if the legal person is treated merely as an administrative tool or device and is treated as an agent of the persons who own it. To illustrate a minor effect of this arrangement, we may notice the impact on those who direct the affairs of such agents who are legal persons. The officials of the state will lose all kinds of immunities from prosecution or litigation. They will be held personally accountable, unless the act they perform was purely for the ummah and the community. In the same way, the concept of limited liability will have to be done away with, and all the shareholders will be held liable for the debts and torts of the corporation, which is an agent of these shareholders. We need not dwell on these issues here. In the meantime, Islamic law needs a free environment for it to grow. This environment is not available to it within the confines of the state, whichever state this may be. The reason, as already explained, is that by inherent design, the goals of the state cannot be in line with the goals of Islamic law. Making Islamic law subservient to a legal person and restricting it within the confines of such a person is detrimental to the growth of this law. This is like granting authority to one group of people to take over the goals of Islamic law. This group will always attempt to impose its own goals over the goals of Islamic law. Islamic law developed by the state will always be viewed with suspicion and will be considered as restricted and subservient to the goals and purposes of the state. If the state is compelled or swayed by the majority in a country to change its laws to the Islamic form, then the first thing it will do is to focus on the experts who will design and develop such a law. The initial attempt will be to employ or engage those experts who are within the state's control and will comply with its wishes. Usually, these will be those who are not qualified, or if they are qualified in terms of paper qualifications, they are those who have bartered away their abilities for worldly gains. This will alienate a large body of the experts in the country, some of whom are really qualified and who often have a considerable following. Even when the ulamaa, as these experts are called, are qualified in the traditional Islamic law, they lack the knowledge of modern institutions, instruments, and transactions on the basis of which modern law operates. This is exactly what we mean by the growth of Islamic law. It should be able to employ the fundamental principles of Islamic law, analyze modern laws, be able to absorb or Islamize them, or reject them and suggest substitute laws. This means a thorough knowledge of modern laws and modern practices. The ulamaa, unfortunately, have been kept isolated for centuries, first by confining them to their madaris, and then by introducing a subject of Islamic studies, which implies that Islam is merely a personal affair. All laws developed for the state, even by the leading experts, are subject to suspicion in the sense of being subservient to the goals of the state and not those of Islamic law. As compared to the state, the law developed by groups that have their own axe to grind or their own goals to promote presents a somewhat different problem. Their goals are driven by greed and the profit motive, and they succumb to the needs of the market, just like a state may succumb to political pressure. The foremost example here is that of so-called Islamic banks and financial institutions. They hire some ulamaa, give them huge benefits, and then get the opinions they want. Stories abound as to how these institutions are using the services of experts for their own goals. The phrase "rent a sheikh" has gained considerable currency, even when an atmosphere of impartiality is created in this process. Like the creation of standard-setting institutions, it is the same experts who are serving the banks who are hired, and they ensure that the interests of their parent institutions are secured. The income source of these institutions is dependent upon the Islamic banks, as is the sale of their products. We may cite the case of the State Bank of Pakistan. The qualification fixed for an expert is Darsi Nizami. This certificate is barely equal to a U.S. high school diploma or equal to matriculation in Pakistan. What is the purpose of this qualification? It is obvious that such a person will not know anything about Islamic law either, besides some acts of worship and probably something about marriage and divorce. As for the complex banking transactions or those of commercial law and negotiable instruments, the person will have no knowledge. He will be more than happy to issue the desired rulings. It is obvious that we cannot expect our ulamaa to act like the earlier imams and jurists. In the early days, some of the leading imams were brutalized and persecuted. Others, like Imam al-Sarakhsi, were locked away in prisons. He refused to issue a ruling in favor of the ruler and was kept in prison for 15 years, where he produced his major works. They bore these pressures with patience and did not yield, for they wanted to maintain the independence and impartiality of Islamic law. It is this independence of the law that was precious for them. It is this spirit that should be precious today, the independence and freedom of the law. The schools did not serve particular governments or rulers. They made laws that would be applicable uniformly all over the Muslim world. If it is assumed that the state may at times be directed by people who are sincere and truly wish to serve Islamic law and develop it, then the ulamaa should have no objection to cooperating with the state under these circumstances. This may be true, but the law will be state-specific. It will not have that kind of universality that is expected from a school-made law that is serving the entire Muslim world. Another problem in this case will be that the state will permit the development of only that part of the law that it needs, and not the other essential parts that are needed to complete the law. The overall, systematic and comprehensive development of the law requires that it be developed in a free environment without the intervening needs of vested interests. Islamic law, in order to grow, must re-emerge on the international scene.